Thank you. So, Attorney, community justice centres, they were creation of Parliament, established by Section 14 of the Community Justice Centres Act of 1983. You made an executive decision to close these centres effective 30 June last year. When can we expect amending legislation to be introduced into Parliament?
In due course.
Can you give us an indication of when due course might be?
No.
So do you think that it's appropriate that you use funding decisions as an executive override to override legislation passed by this Parliament?
The government has the ability to fund or not fund programs as it sees fit.
So is it the government's position that an executive decision to withdraw funding can effectively nullify a statutory scheme created by Parliament?
No, because DCJ are fulfilling the mandatory statutory requirements in relation to mediations under the Act.
Are they fulfilling Section 14, the creation of community justice centres, Attorney General?
They were created. That's been discharged.
So you're basically arguing, provided you can do a workaround, you don't need the approval of Parliament to change the way that legislation approved by this Parliament operates? We can fund programs as we see fit, and I can get you the statistics about the mediations that DCJ has done. I'll come to those this afternoon with Mr Tidwell, if I may. I'm keen to understand those. Do you consider that as a minister, as a member of the executive, you are accountable to this Parliament?
Of course.
Well then, why won't you bring this legislation to this Parliament to see if the people's representatives will endorse your executive decision?
Well, we will in due course.
We've been waiting a long time already, Attorney. The Anti-Discrimination Board is required by legislation to have how many members?
I'd have to check.
I believe it's 5, according to Section 72. Does that sound right to you?
I just said I'll have to check.
How many members are currently serving on the board?
I'll take that on notice.
Or surely you can tell me now.
Someone can answer.
I think Mr Daith could tell you, couldn't he?
3? So acting president and 2 other members at this stage.
So 5 according to the legislation, 2 and the acting president. And of course you've got Mr Daith serving as the acting president while he's also a very busy deputy secretary with responsibility for courts, tribunals and service delivery. Do you consider that the president of the Anti-Discrimination Board is a significant job if you think it can be managed on the side by a busy deputy secretary?
So recruitment is underway for a president, and we'll be filling the rest of the board as well.
What's the last matter that you referred to the board for report?
I'll take that on notice.
Okay. We're about to reach the 2-year anniversary of the last time you made any appointments to the Anti-Discrimination Board. We understand we have 2 vacancies to be filled. Are you planning to quietly run down the Anti-Discrimination Board in the same manner that you're doing with the community justice centres?
No, not at all.
Well then, why have these positions been left hanging for almost 2 years?
Because we've been having a good look at the Anti-Discrimination Board, and it's taken longer than I wanted, but recruitment is underway now for a president, and we'll be filling the board. And Mr Daith's done a good job.
I'm not contesting
and in addition to that, we are going to increase the president's role from a part-time to a full-time role. So it's certainly not.
And you'll be bringing that to the Parliament, or you'll just be deciding that as an executive function?
I'm not sure what the process is for that.
Well, it's created by the legislation, so I think presumptively it would be in the legislation.
Well,
Wouldn't
I don't
you agree, Attorney General?
The legislation might create the role, and then the government can work out whether it's full or part-time, and we've decided to make it full-time. Do you have a problem with that?
I have no problem. I have a problem with massive inaction, Attorney General. I'm just wondering when we can expect you to turn your attention to the Anti-Discrimination Board and fill positions that have been left vacant.
Well, we've turned our attention to it. We discuss it on a regular basis. Section 80 of the Act says, in fact, that it can be full or part-time, and we are filling it.
Thank you. Following the changes made by the Equality Legislation Amendment LGBTIQA+ Act, what steps are you taking to make sure that the children in respect of whom we are now facilitating parentage orders are not born of slaves?
We've been through this. I refer you to my answers in previous
I'm asking you again because you have never answered this question, Attorney.
Because you can't adequately described to me what the issue is and what government might be able to do about it. So I'll just refer to my previous answers.
We went through this last time
That's
where I
right.
explained it to you
Yep.
because apparently you voted for legislation without understanding its impact, which I find very distressing, especially because you brought this legislation to the Parliament. The
Well,
impact
actually,
is
I
very
didn't.
clear.
Actually, I
It has
didn't.
been explained to us by the Anti-Slavery Commissioner that we are facilitating parentage orders for children born overseas without checking whether they are born of slaves. You said in your second reading speech that, quote, appropriate safeguards would be put in place. What safeguards are you putting in place to make sure that we are not abusing women overseas in slavery to provide children for New South Wales families?
So DCJ is completing a review now of the Surrogacy Act. Which
Was this a term of the review?
Which fulfils a commitment of government made before the 23 election. A range of stakeholder views have been received. Submissions have been published on the DCJ's website. And the Anti-Slavery Commissioner has provided a submission to DCJ's review of the Surrogacy Act and the Status of Children Act. The submission is available on the website, and currently, commercial surrogacy is prohibited under the law in New South Wales.
When was the last time there was a prohibition, there was a prosecution for commercial surrogacy in New South Wales?
I'd have to take that on notice.
Thank you. And I ask you again, when will you address the plight of overseas women being used as slave mothers for families in New South Wales?
Well, we'll consider all of that in the review of the Surrogacy Act.
I'm sure those women would love to hear that answer. Minister, you provided the government response to the report of the Legislative Council's Standing Committee on Social Issues, the impacts of harmful pornography on mental, emotional and physical health. Did you read that report and its recommendations?
Yes, I did.
And you were responsible for the response, which mentioned the Safe Ways and New Street services, which are designed to support children displaying harmful and problematic sexual behaviours. And you'd be aware that those problematic sexual behaviours include child-on-child sexual abuse, which now accounts for about 50% of the sexual abuse suffered by children. The government response does not respond at all to the recommendation made by that committee that these services be adequately funded. Why didn't the government response address the issue of funding for these critical but underfunded services?
Because funding for all government services is done on a budget-by-budget basis and not in respect of a submission or a response to a report.
The government response didn't even acknowledge that there was an issue that these services cannot fulfil. Professor Tolliday gave evidence to that committee in relation to sexual abuse perpetrated by other children, and that these programs, quote, cannot even come close to meeting the demand. That clear recommendation, that clear evidence, was not reflected in the government response at all, which essentially said, Health's got this under control. Next. Health clearly don't have this under control, Attorney General. If you read the recommendations, if you read the report, why were you happy to sign a response which indicated no engagement with the recommendations and no intention to actually seriously look at what is a major community problem?
I don't know that you can read all of those conclusions into our response, and if insofar as Health is responsible for the implementation of those recommendations, it's a matter for Minister Park.
But Minister, you signed the response on behalf of the government. You were responsible for that response, which did not acknowledge this pressing issue. What is your government going to do to address the needs of children who, because of early and over and inappropriate exposure to pornography, are acting out on other children and give them the services that they need?
So I think it's a mischaracterisation to say that we've done nothing. We legislated to protect women and girls from image-based abuse before the committee even handed down its report.
Yes.
Last year we introduced and passed legislation criminalising the production and distribution of sexually explicit deepfakes. The committee's recommendations largely related to health and education and programs, and work on these recommendations remain ongoing. So we're always reviewing our laws to ensure they're fit for purpose and to provide law enforcement with the tools they need to do their job in this regard.
Happy to hear that, but I raise again, the Safeways program, the New Street Services program, cannot meet their need, don't even keep a waiting list because they have no capacity. Critical service that your government needs to support. I'll hand over to my
I
colleague.
hear that.
You're the delegate, I understand, Mr Tidwell, in relation to making decisions under the Premier's Memorandum M 2022-10, the guidelines for the provision of ex gratia legal assistance.
I am indeed.
Yes.
Don't
Don't
I know it?
last time. You should get danger money for being that delegate, I suspect. In accordance with that delegation, did you receive a request to pay legal fees in respect of the matter brought by Mr James Cullen against the President of the Legislative Council?
I did, and I rely and take advice in these matters. When that matter first came to me, I believe I was on leave. Ms Campbell made the initial decision in my absence, but it does reside with me. So the initial decision was made by Ms Campbell as acting secretary. Subsequent decisions have come my way.
Okay. Ms Campbell or Mr Tidwell, whoever's appropriate.
You can effectively take it. I fully endorse
thank you.
the
from
position
whom was
taken
the
by Ms
request
Campbell.
made?
So I'm happy to
Yeah.
take the questions.
From
initially.
whom was the request made?
Sorry,
Who made the request? Was it from Mr Cullen? Was it from somebody else?
it's Mr Cullen.
Mr Cullen made the request. And what was the outcome of the request?
Well, these matters are always subject to being tested against the memo, which is an administrative memo. It's not
I'm very curious how this matter was tested against that memo.
Well, if I can
Please.
assist the committee,
Please.
which would be my aim, just going to the applicant must be a public official.
Yes.
Their involvement in the proceedings must relate to their official duties, and they must have a substantial and direct interest in the proceedings. The direct department head, in this case, it was the Cabinet Office, must also support the application for ex gratia assistance following.
So just to be clear, you
Yeah.
received the request from Mr Cullen, but it was supported by the head of the Cabinet Office.
Correct, and that is a requirement
Yes.
pursuant to 2210.
Yes. Yes.
So it must be supported, and as I was just saying, following a thorough department investigation into the circumstances giving rise to the proceedings.
And did that include an opinion about prospects of success?
Not to my memory.
Right. Okay.
It is considered that a public official includes ministerial staff
Yes,
employed
agreed.
under the Members of Parliament Staff Act of 2013. And can I just say, in circumstances where the Privileges Committee was looking at a possible contempt arising from the Rosehill Racecourse inquiry, and the applicants could face criminal prosecution if they did not comply with the summons, which it was anticipated to be issued, it was open to find that the applicants had a substantial and direct interest in the proceedings. So, and as I've said, the applications was approved on that basis, but with the endorsement of the Secretary of the Cabinet Office.
And of course, that memorandum is further qualified by the guidelines, and the guidelines really make it very clear that you're talking about a defensive legal action where this really can only be characterised as an offensive
This is
legal
an
action.
can I just say,
Yep.
I would be the first to acknowledge that this is an extremely rare matter, in that the consequences of warrants being issued and curtailment of liberty and other things were profound, and it is in that sense exceptional, and in that sense I stand by the call I made, and on that basis I accept the scrutiny, but I absolutely stand by the call that was made.
And as you've just said, the potential deprivation of liberty and other processes only applied if people did not comply with the summons. So what we have here is a situation where we are saying that it is entirely appropriate to authorise payment for legal proceedings for people who are setting out and in fact planning, apparently, not to comply with a lawful summons. That seems extraordinary to me, Mr Tidwell.
I have spoken to the best of my ability about the things which were foremost in my mind, and to the reasoning that I brought to what I accept is a serious responsibility in the administrative tasks arising from 2210.
What was the total amount of the money that has been disbursed?
Under the application from memory, it is, and I can check it in a moment, I think it's $219,000.
$219,000?
Yes, I will, if I'm wrong in my memory, I will correct that through.
And has a further application been made?
I can confirm what I've just said.
Thank you. And has a further application been made in respect of the costs of the appeal?
Yes.
And what was the outcome of that request?
I think it's more of approved,
Okay.
but obviously that is a process yet to run.
And I'm curious, with respect to costs, is the agreement to meet party costs, solicitor client costs, every single cost that's incurred?
So
Is it full indemnity or is it?
So it's an order of court, wasn't it?
No, the
oh,
costs
sorry.
that are being met on Mr Cullen's behalf by the taxpayer of New South Wales. Is that full indemnity?
It's moderated. It is moderated according to a...
It's moderated according to the AG's rate. So this is the engagement of a lawyer. So it's not like a court-ordered costs award.
No, I'm just trying to understand exactly.
So we pay for, the public purse pays for Mr Cullen's representation.
And
at Attorney General's rates.
And so his solicitor accepted Attorney General's rates?
That is my understanding, yes.
Can you confirm that on notice, please?
Yes.
Yep.
And his barrister accepted Attorney General's rates?
To my knowledge, yes.
Can you confirm that on notice, please?
Yes.
Because I understand that would be a significant discount for the counsel that was involved.
I'm not aware of
Look, we have some outstanding counsel who are here in a range of matters who accept the government rate.
Okay, great. Thank you. I'm curious about this whole proceeding. So are you familiar with the case of Clayton and Heffron, Mr Tidwell?
No, I'm not.
Mr McKnight?
Mr McKnight, are you familiar with that, Clayton and Heffron? That was the last time that a Labor Premier tried to take action against the Legislative Council. And in that matter, the Labor Premier was suing, in fact, all the way to the High Court to be able to take the matter of curtailing the powers of the Legislative Council to the people of New South Wales in accordance with 7A of the Constitution. Yet this time, we have the Chief of Staff of the Premier, funded by the New South Wales taxpayer, taking action against the Legislative Council in order to contest the ability of the Legislative Council to exercise its powers of review by summoning witnesses. Do you find that a curious use of taxpayers' money?
My job, as I've taken it, is to exercise my responsibilities as arising from Memo 2210, and that is what my exclusive focus was, not matters of broader policy, which I may have opinions on them, but the task before me was confined and it was clear.
So, in your deliberations about funding, did you consider the issue that this case, brought by the Premier's right-hand man and paid for by the Premier's government, is an example of overreach by executive government trying to cut out both Parliament and the people who elect them?
My reasoning was applied to the parameters and the reasoning and the provisions of 2210, and that was the basis upon which I made the determination which I did.
Thank you. I want to move on to the closure of the community justice centres. Is
Yes.
that you, Mr Tibble, as well?
Right.
Right. Has the
Let's find out.
has the DCJ mediation service, which was to replace it,
Yes,
commenced
it's up and
operation?
running, and I have on me, there have been a number of matters which I read in prepping, Ms Carter, which
Yes.
have actually been resolved, and I can provide that number.
That would be great, thank you. At what locations does the service operate?
Can I, again, happy to provide? I don't.
Yes,
off
no,
the top of my
I'm
head.
happy to take this
Yep,
on
thank
notice.
you.
I'd also like to know what hours it operates and in respect of which matters it provides mediation and how interested persons are made aware of the existence
Happy
of
to
the
assist the committee
service.
with that.
How many mediators are employed?
Right.
Okay, what's the cost of running this mediation
Yep.
service?
So it would not be an existing cost. It would be, again, if I could
I mean,
take that on
I
as-
assume because it's a new service, it's an additional cost, so I'm interested in knowing what the
I'm
cost...
certainly happy to, in my response, advise
Yes.
the committee of any additional cost.
Thank you. And what work has been done to assess the impact on local court listings of the closure of the community justice centres?
To my knowledge, we have not felt the need to do that, and in terms of filings and discussions with the heads of jurisdiction, there's been no sense that this has added to workload of that jurisdiction.
So is this a question that's been asked, or is this a rock we just haven't kicked over to find out?
I wouldn't characterise it in the under you using the
Okay.
words in your letter.
I understand you
I
wouldn't
don't
characterise it that
accept.
way.
I
Yes.
don't accept that. I talk regularly with the Chief Magistrate. We regularly talk about drivers of workload.
Yes.
This is certainly not arisen.
And do you have similar conversations with the Land and Environment Court?
Of course I do.
And are they noticing any additional workload there?
I meet regularly with Chief Judge Preston. It's certainly not been raised as an issue.
Okay. And has any other work been done to assess the impact of the closures?
I won't say no, but I would appreciate it if I could just confirm
Oh,
that
happy
in
to,
advice
for you to
back
take
to
that
the
on
committee.
notice. No, I'm interested to know what's happening.
Of course.
This is not designed as a gotcha. Has legislation been prepared to reflect the government's decision to close the community justice centres?
No,
So it hasn't been prepared yet.
that is my understanding.
Okay, thank you. At last estimates, the Attorney General advised that a monitoring group had been established to review the operation of the new bail division. How often does that monitoring group meet?
It's not me.
Can I take, there is a monitoring group.
Sure.
Can I take that on notice? And certainly just in terms of bail centralisation, there is formal mechanism, but there is also a lot of discussion with the stakeholders, the court,
Oh,
legal aid.
yes.
We are being very diligent
Yes.
in looking at all the impacts and the loadings arising from that work. Happy to
I
provide
think
a
everyone
more
in here is
fulsome-
aware of the considerable discussion that's
So
happening in relation to the bail
happy to
division.
provide a more fulsome response.
Yeah. Well, on notice then perhaps, how often does this monitoring group meet? Who are the members of the monitoring group? And what input has been sought from practitioners by that monitoring group about the operation of the bail division? And where are we with the early cut-off and the impact that that's having? Can that be revisited?
Can I just...
Yep, sure.
Thank you, Mr McKnight. So in respect of the Bail Division Monitoring Group, it meets fortnightly, I can advise the committee.
Great.
And includes representatives of the Chief Magistrate's Office, the Children's Court, Corrective Services New South Wales, Police, DCJ Court Services, Policy and Reform and Legislation Division, Mr McKnight's area, Youth Justice New South Wales, Information and Digital Services within DCJ, given the tech issues involved, Legal Aid, Justice Health,
Yes.
Multicultural New South Wales, the Aboriginal Legal Service, and the Law Society of New South Wales and the Bar Association.
Great. And do they publish minutes or reports?
I don't believe they publish minutes.
Okay.
I imagine there would be minutes.
Okay. So how does the rest of the community find out what the fruits of the monitoring process
So
is?
I believe that, so the Law Society, that the two professional associations have strong connection with the profession and the users through that, the users of the court. Part of this is obviously to provide continuous feedback and reflect the experience of users of the court. It is also about ensuring that the communication is two-way.
I'm very interested to hear that there are representatives on that committee in relation to digital work. Where are we with digitisation, which, as I understand it, would really facilitate the operation of that bail division?
So the bail division relies very heavily on, obviously, on digital capability.
But as I also understand it, Mr Tidwell, what's happening is rather than being able to transfer information digitally, all too often it's needing to be emailed or faxed, which is taking considerable time to move large amounts of information rather than being able to just share a file digitally.
All right, so there certainly has... so we're not talking AVL, we're talking... in terms
So
of the
there's
specific
AVL,
technology.
which
Yeah,
is...
yeah.
Do we have AVL in every courthouse in New South Wales yet?
Can I just turn to...
Have we got it
Mr.
in
Dave
Boggabilla?
on that?
Because I think Boggabilla was the issue last time.
I don't have the answer specifically about each court.
Can you
courthouse,
take that
but
on
I'm
notice?
happy
Could
to
we
take
maybe
that
get a
on-
list of which courts do and which courts don't have AVL access?
We can take that on notice.
That'd be great. No, I was talking, really referring, I mean, to how you transfer the court files, because you've got a solicitor in point A, you've got an offender in point B, and you've got a judge in point C.
I take the note. That's
Yeah.
a good question. Mr. Dather, we can either take that on notice to give you a proper response, and of course open
I'm happy to take-
And if there are locations where, of which you have knowledge, where there is particularly difficulty, keen to know about those.
My
But
understanding
anything you
is
wish to
there
add?
is difficulty with transferring information from almost every location to every other location in terms of the time that it takes because of
Yep.
the methods that need to be
Yep.
employed. And I'm really happy to take things on notice. Can I
Yep.
make an observation that we have become wary about taking things on notice because all too often that is used as an excuse to provide a very superficial answer, often to a question that was a bit different to the one we were actually asking. So if we could have serious engagement with the questions, I'd be really grateful.
I can assure you that if that is the case, that is certainly not the intention.
Thank you. No, thank you. Sorry, where are we with the cut-off times and the issues that the police are having and the impact on policing having to hold offenders in cells if
So,
they've missed the
yeah,
cut-off time?
Absolutely. So a lot of work has been undertaken over the last 3 or 4 months. So there have been meetings held with the courts, with myself and the Corrective Services Commissioner. A huge amount of work has been undertaken on what I would characterise as bed flow. Corrections has, particularly at Silverwater, done an immense amount of work to ensure that that reception bed capacity is there to cope whatever this. And can I say, there are moments of surge. So you're probably aware that over the January period, there's always quite a dramatic uptick in the remand population. There are challenges that arise with that. I receive a daily report. I have been for approximately the last 6 weeks with a real eye to ensuring that the bed flow is working. Can I say with some notable exceptions when there have been very difficult days.
We may
there
get
are
cross
zero.
purposes.
We
Yeah.
are generally having, most days by far, we're having everybody flowed in without needing to be held in police cells.
Okay.
The exceptions are reported to me. Where the exceptions are more than 10 across the state, the Corrective Services Commissioner and I talk on the day on what the issues were, and it's in a good place, but I believe it's going to stabilise and work exactly as it should.
It's encouraging. Thank you. A quick question perhaps to Mr Daith. AVL in Corindi, is it true that Corindi has been advised that they're too close to Tamworth to get AVL there and the police are now having to transport everybody to Tamworth for bail?
I do recollect a question in relation to that. I can find the full details and
Can you,
take that
because
on notice.
do you know the travel time between Corindi and Tamworth? Perhaps you could find that out on notice too, and the state of the roads and a few issues like that,
I
and
was in
how
that-
much
I was-
police time it takes to
I
transport
was in
people.
that area at the beginning of last year, so I've got some recollection
Right.
of that when I went from Tamworth through to Moree and saw Narrabri and other locations. But I'll take your question.
Yeah,
on
but
notice.
if you could, because it's
Indeed.
a serious issue. Ms Hitter, just quickly, there's a large amount of money, I think the attorney said something in the order of 18.5 million waiting for the tender process. Will the interest that accrues on that money also be added to the money available to the CLCs?
Ms Carter, before I answer, I'll just remind the committee I've not taken an affirmation this
I'm
morning.
sorry.
And yeah.
You've already been sworn in the last budget estimates.
Is it from the last budget estimates?
Yeah, the
Okay,
initial
fine.
one. The initial one. And my
Thank you.
apologies if that wasn't clear. Thank you, Ms. Hitter. You are free to speak however you see fit. Thank you.
Thank you. Apologies for the
No.
question. My understanding is that the amount is there from the point of view of how much the Commonwealth has indicated is available for CLCs. I understand indexation is part of the funding, and it's set at a particular rate, but I'm not clear on what that is, to be honest, so I can take that on notice.
Thank you, yeah. And the tender will be for 5 years of funding or for 1 year of funding?
My understanding is that it's for the life of the agreement, so it's for 5 years.
And when do you anticipate that successful CLCs would be able to receive those additional funds?
So the tender process is due to begin on the 18th of March. All of the steps to make that happen, I believe, are underway or have happened. We've engaged an independent probity advisor. There's a panel that's been
It's a torture
approved by
process.
the attorney. And so we're set to go for the 18th of March, and then it will be a question of how quickly the panel can get through the
And
applications.
who pays for the tender process? Does that come out of the money available, or who funds the tender process?
My understanding is that it is part of the administration funding for the CLC program, but I can confirm that.
Thank you.
But that's my understanding, that it's part of the administration
Great.
of the program.
Thank you.